Mexico fires back, no pun intended, at the United States with a lawsuit trying to hold gun manufacturers responsible for what happens on the other side of the border, like all the gun dumping and all the gun violence that comes from not Mexican gun manufacturers, U.S. gun manufacturers. But the Supreme Court had a different idea, and we break it down on Unprecedented, a show only on Legal AF YouTube channel. And here's a clip. Speaking of foreign and foreign powers, Mexico and Claudia Sheinbaum, the president there, in a case that was started by her predecessor, Mexico brought a suit against the United States because of all of the guns that proliferate on the other side of the border. There's always these stories on the U.S. MAGA side about build the wall, stop the Mexicans from coming in. Except when they, everybody here wants to go to Acapulco or to the Yucatan Peninsula or go on vacation or Cabo, and they never think about and all of half of our automobiles are built in Mexico, and all the hardworking people that help support the U.S. economy are in Mexico. And Mexico also is on the wrong end of drugs, not just drugs going out, but drugs coming in. And they're also on the wrong side of guns coming in. They're not the gun manufacturers. The U.S. is the gun manufacturers.
Yeah.
So there's been a law in the books for quite some time. This is one of the things that this has to do with voting matters. And a Congress a long time ago got together and because of the strength of the gun lobby at the time and even now, gave them a pass from liability for selling their product in commerce. There's some exceptions to that. But by and large, it ousts state regulation and other civil lawsuits and gives gun manufacturers liability insulation. And that's been on the books for quite some time. And Mexico had a state case that they thought they had a way around it, made its way up to the United States Supreme Court from an appellate decision. And we have a 9-0 ruling that's written by Justice Kagan. And what happened there?
So Justice Kagan said that the lawsuit brought by Mexico against the gun manufacturers can't proceed based on that congressional act. If that congressional act was literally meant to not allow for these lawsuits, because the fact is that the gun manufacturers sell their guns to licensed distributors who then sell their guns to licensed dealers. And so linking it down so far down the road to crime in Mexico was exactly what the act was intended to prevent. And that act really, I think, if we truly want maybe gun reform, we should repeal that act, because to your point, like that is what allows, we just talked about now there being a flood of lawsuits against companies. It protects gun manufacturers from a flood of lawsuits for crimes here, even in the United States. And even if people didn't win all those lawsuits, like, again, there's the litigation burden. So it's definitely putting, benefit to gun manufacturers, this congressional act. But here's the thing is, the Supreme Court, when Congress has written a law clearly, and that's kind of a key term, don't you think, Popok? When they have clearly written the law, the Supreme Court will defer to that because of the separation of powers, right? It's really only when the language is vague, maybe they have written two conflicting or two provisions that seem to conflict, that the Supreme Court will kind of not seem to defer to them as much. But in this case, the congressional action, and also in the case of the reverse discrimination case we just saw, it wasn't so much that the 9-0 majority believed that the gun manufacturer should have limited liability, or that a majority group should not or should be allowed to sue easier. It is that Supreme Court all agreed on how Congress wrote the act and intended it to apply to the facts. And that's, I think, important in case people are wondering, like, how can the Justice Kagans of the world or whatever, like, side with what we think is not a great outcome? It's because that really is what they were looking at. how well does this act apply? And it squarely applied. And so that was why the case that was dismissed, and the Supreme Court upheld that dismissal.
Yeah, and again, we're here on the Kumbaya episode of which I'm not totally buying. The same reason, and it's the same reason I don't buy that the gun rulings that came out a week before
that's a good one.
are really long-term pro-gun control rulings by the Supreme Court. So 2 cases came out, one in Maryland, speaking of Abrego Garcia in Maryland, and one in Rhode Island. Maryland has had on the books for quite some time, coming off the Sandy Hook elementary school massacre, a ban against AR-15s. There's about 18 states that have it. But AR-15s, which look to be military grade for me, the automatic AR-15 semi-automatic long gun is in the hands of tens of millions of Americans for sport and for target shooting. Unfortunately, they also fall into the hands of teenagers and others in mass shooting events and school massacres and the rest. And so Maryland had a ban, and the question was, did the Second Amendment allow an AR-15? Or is it something that's more akin to military-grade weaponry, like an M16, which the courts have uniformly said is not covered by the Second Amendment? You don't get to have an M16 at your house, or a rocket launcher, or other things. So that was the battle. And on its face, it kind of looked like, when I first saw the headline, it kind of looked like, oh, Supreme Court got their act together and they're going to allow for AR-15 bans. And then you read, it was really procedural. And then you read Kavanaugh's statement, Karen Freeman-Agniflo, our colleague, said to me in Legal AF recently, I didn't know they made statements. I thought it was either a concurrence, a dissent, or they joined the majority opinion. But he made a statement. And the statement was basically inviting the future case where they're going to rule, and I think they've got the numbers, that an AR-15 is something that is protected by the Second Amendment. What did you make of that decision? And then the other one was about high capacity magazines in Rhode Island. But I didn't take. I took very cold comfort from this decision, and Kavanaugh basically saying, I don't know about this term or the next term, but we're going to get to the bottom of AR-15s and Second Amendment. What'd you make of it?
Yeah, I mean, I agree that this is going to be like just the beginning, as you said. Well, I mean, at least that Thomas and Alito and maybe Gorsuch, Kavanaugh want it to be just the beginning. As you said, there was the Maryland decision. There was the Rhode Island decision that had to do with high capacity magazines. And, I thought it was interesting because, just a quick recap, the Supreme Court's kind of major decisions on this. The Heller decision in 2008, written by Justice Scalia, was the first time there was enshrined this idea that we have a personal right to bear arms. So if you ever have a Trumper talking about judicial activism, there is a good example. And then we had the Bruen decision not that long ago that again kind of did another huge takedown, let's say, of our trying to get weapons of war out of our system. The Bruen decision, which basically struck down the New York concealed carry law. The Fourth Circuit that was looking at this basically said the reason why they were able to upheld the decision within the framework of we have to look at history, because that's what the Supreme Court kind of initiated that framework, was you don't need this weapon for self-defense. It is an unnecessary weapon. So that way it still fits within the firearm regulation. And what Thomas wrote, that one was just, I couldn't believe he wrote it with a straight face, because he was, of course, dissenting. He wanted the Supreme Court to take up the case. And he said, and I'm just going to, he said that the AR-15s do not fall within the historic exception for dangerous and unusual weapons, because AR-15s are not unusual, but in fact, the most popular civilian rifle in the United States. So the fact that he thinks that they're not unusual for for people to basically carry around military style weapons, I can't believe he could say that with a safe face. I mean, the fact is a lot of people, as you say, use it for hunting. Hunting is not a mode of self-defense, right? So this is what the circuits we're really looking at, is whether or not the high capacity magazines or whether or not the military style weapons are necessary for self-defense. And the First Circuit in the Rhode Island case said, no, because you don't need to rapidly shoot 10 times to defend yourself. So you don't need this high capacity magazine for self-defense. So that way it also fits within this historical exception. So, if the Supreme Court wants to take up this case and allow for bans on high capacity weapons and military assault rifles, they're really going to have to say that somehow this is something that the founders conceived of, wanted, that people have to carry this for self-defense, because saying that they want it for hunting is not even within part of the Supreme Court's decision, like their opinions. This is why the circuits are all looking at whether or not you need it for self-defense. We do balance our rights. Having it for hunting is not going to overcome, this public security need to defend, to ban it. So anyway, so that's where we are there. Again, no decision made, not taking up the case. As you saw, there's a group of them that certainly want the Supreme Court to take it up again in the future, and we'll have to see if they win out or not.
Yeah. So that's where we're at. They're going to take the case up. They're going to fine AR-15s, at least the 5. I think there's 5 votes for it, unfortunately. But we'll continue to report on that. And there's some other cases that are coming up that you and I will discuss. The summer is filled with holidays and vacations and now emergency petitions because of Donald Trump. That's Dina Doll and me, Michael Popok. We do the show once a week. We're going to do it right through the summer, all the way up to the next term. We sit at the intersection of law, politics, and the United States Supreme Court, so you don't have to. We put it in context. We use our powers as legal analysts, as practicing lawyers, as constitutional, dare I say, scholars, to put it all in perspective. We're glad you're here. While you're here, you can vote for this kind of content by hitting the subscribe button for Legal AF. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.